Hello landlords, it's Ernie Garcia, landlord attorney, and today we're talking all about ordinary wear and tear. What is it? How do you plan for it? Let's get started. So I want to give you 5 tips on how to address the issue of ordinary wear and tear when it comes to your rental properties. The first is to establish a baseline. It's difficult for you to make a claim after a year or multiple years to a tenant that they have in some way injured your property. Remember, it's going to have some wear and tear. That's an ordinary thing. And so the longer that a tenant is on the property, the more wear and tear your property is going to exhibit. The question for you is, what goes beyond that level? And the easiest way to establish that is by establishing a baseline. And that's done quite simply by simply having a record of the condition of the property before the tenant ever takes possession or control of it. Now that's completely on you, the landlord, to establish. What do the floors look like? What do the walls look like? What's the condition of the ceilings, the roof, the plumbing? What are the appliances like? Is everything brand new, or is everything already kind of old and falling apart anyway? All of this information is vital to the establishment of a baseline. And once you've established what the baseline value of your property is and its condition, you can then allow a tenant to reside in it, and any substantial difference to that baseline is where you're gonna base your determination that the use was not normal. So the easy one is carpet. Let's assume, for example, that a tenant comes in and you've just installed brand new carpet in year 0. Now for a tenant who stays there for simply 1 year, if the carpet is destroyed after a single year, you can say that replacement of the carpet goes over and above normal wear and tear, because carpet should last well beyond a single year. But let's say the same brand new carpet is installed, and instead of 1 year, the tenant has been there for 5 years, and instead of completely destroyed, there are some rooms where the carpet is worn away, there are stains, there's signs of wear throughout the home, but that the carpet is otherwise in fair condition. Well, depending on the number of years, if again, after 5 years, the carpet is in fair condition, that's probably about as good as you could expect. You can't expect brand new carpet when it's been in use for 5 years. And so if you get it back in a fair condition, then you can't assess fees for brand new carpet when, again, after 5 years worth of use, that kind of wear and tear is completely to be expected. Next, if you're looking to protect your house against things that go beyond ordinary use or ordinary wear and tear, the second thing that I recommend is setting up your own house rules. Many landlords already do this. Make sure that your rules include how the property is to be cared for and maintained. So one easy example is a no smoking policy. If your lease is not explicit, or if you left it ambiguous in your lease, that's a problem. But your house rules should explicitly prohibit smoking unless you bargain with your tenant otherwise. If you permit smoking inside the house, you can expect certain odors, and you can expect to have to rehabilitate the property after the tenant has left due to the presence of cigarette smoke. But if you strictly prohibit it, and upon move out, you can detect that the tenant was in fact smoking. In fact, if you inspected the property and you could tell by your inspection that there were ashtrays all over the premises, you can deduce that smoking is happening on the inside, especially if you come in and you can smell it. So by having your house rules and by actually inspecting the property, you can enforce those rules so that, again, at the end, if you can establish that damage has been caused beyond normal use and a prohibited conduct is not normal use, once you can establish that damage has been caused, you can use this evidence against your tenant to collect for these damages. So as mentioned before, with the prohibition against smoking, you're going to want to look at the language in your lease. Does it explicitly address the issues that you want taken care of on your property, having to do with, for example, yard maintenance, or perhaps a prohibition against the tenant actually tinkering or in any way altering the premises? You don't want to know that your tenant has illegally installed all sorts of equipment into walls or drilled holes into the floors without asking you. So you want to make sure that the tenant knows and the lease explicitly prohibits, alteration to the property that would effectively scar the property or change the property in a way that would cause you economic damage. Landlords, as always, we welcome you to follow us on our Instagram page. If you're not a member yet, join us on Facebook. And if you enjoy what you see here, give us a thumbs up. Click that like button. We enjoy that very much. And if you haven't subscribed yet, please consider subscribing. Now, the fourth tip for you is to have actual proof of your actual costs. It's not enough to show up to the court with estimates or your speculation of what these damages are. If a tenant has vacated your property and has in fact damaged your property beyond normal use and beyond normal wear and tear, you're going to want to show up to the courthouse with actual receipts for actual damages that you actually paid for. This is going to be your best evidence to prove the amount of money that your tenant owes. Once you establish the fact that the damages that you've experienced exceed normal wear and tear, you're going to want to show the court precisely what it costs you in terms of dollars and cents to get these repairs completed. Again, for people who show up and make a claim, for example, well, I've been damaged in this amount, I haven't done any of the repairs yet, but I know it's going to cost me this. That's a weaker argument to the court, because the truth is you may never, make those alterations, or you may never make those repairs. But if you have made the repairs and they were necessitated by the damage caused by the tenant, you have a stronger argument of actual injury that you can demonstrate to the court. Have those receipts handy and ready, and have them ready in the event that the opposing party in this lawsuit or this claim that you filed wants to review them. It's possible that before you ever get to trial, the tenant will review these damages, see that they are reasonable, and make an offer of settlement to cover your actual losses. So the final tip that I want to give you has to do with the 50-50 rule. And this is a rule that I share with landlords, and I hope you find this helpful. A lot of what we deal with in this section of property management is that gray area where it's kind of hard to tell whether or not the damage that you've experienced is normal wear and tear or it exceeds normal wear and tear. So I like to talk to landlords about holes in the wall. So is it normal for someone to hang pictures? Absolutely, perfectly normal. And so you're going to get some damage to the wall, but it probably constitutes normal wear and tear for them to leave a few scuffs, some holes. I don't know that you can replace the entire wall because a couple of nails were drawn in. That probably goes too far. But certainly holes punched into a wall are not normal use and not normal wear and tear. So if it's black and white, very easy to figure out, it's not a problem. But if you come across an issue that is a 50-50, and I tell landlords this all the time, if it could go either way and you can reasonably deduce that some judges might see it this way and some judges might see it that way, the truth is it's just not worth it. If, for example, you're assessing damages after a tenant has moved to calculate the amount of the security deposit that you're going to refund to your tenant, and you've got a list of items that are slam dunk, absolutely, they broke the thing. For example, a broken window. There's no normal use that a tenant can have where the window ends up broken. And so if they used it, they broke it, they owe the cost to repair it. But other things are sometimes not quite so cut and dry. So let's go back to the example with the carpet. Let's say instead of 5 years, it's been 3 years. So generally speaking, you can expect carpet to last about 5 to 8 years through normal use. But let's say in this case, brand new carpet was installed and 3 years later, you get the unit back and most of the rooms are just fine, but one carpet has excessive damage. And it happens to be the living room carpet. There's lots of traffic through, and maybe there aren't exactly holes, but the carpet is worn down in such a way that it probably will need to be replaced. And so, but it's unclear to you whether the carpet was misused. You know, for example, that this particular family was at least 5 people that were at or near the adult age. So these aren't small children, and it's not a single couple or a single individual. You're talking about 5 at or about adult aged individuals up and down, in and out of the living room on the carpet for 3 years. And so this might be a tough one for a judge to determine whether or not this exceeds normal use, considering the number of people and their ages and maybe their weight and size. The fact is they could have been using that carpet in an absolutely normal way, and the quality of the carpet might be what's in question. And so in your mind, at best, this is a 50-50 argument. Well, what I would pose to you is it even worth presenting a 50-50 argument to a court? And you always want to think about it in terms of what is this going to look like in a lawsuit? So that if, for example, you've got a $1,000 deposit and you can establish quite easily $200 worth of actual damages that you paid in order to rehabilitate the home for things that went over and above normal use or normal wear and tear. But now you have this issue of recarpeting this one room, and the cost will potentially take up the rest of that security deposit. And so you have to ask yourself, I can clearly see 200, easy to prove. The next 800, not as easy to prove. If I wrongfully withhold this $800, I could be sued for up to 3 times that amount, plus attorney fees, plus court costs. Is that worth it for a 50-50 argument? And my response is always no. If in your mind you've got a 50-50 argument, you probably shouldn't go with the deduction. If you have a significantly stronger than 50% argument on your side, justifying you assessing the damage claim against the tenant, then it's probably safe that even if you are sued for wrongful withholding, because you've got a strong position, you will likely turn out successful when you present your case to the court. But a 50-50 is, in my opinion, just not worth the risk of getting hauled into court on this claim. Again, 3 years and you got to replace the carpet in one room. That might just be something that you chalk to normal wear and tear, or close enough to normal wear and tear that you invoke the 50-50 rule and say it's not worth it. I'd rather take the loss than risk being sued and at best having a 50-50 shot at recovering these damages. Again, the headache of a lawsuit, the cost of your own defense, and then ultimately the cost that you might incur for wrongfully withholding a deposit is enough probably to dissuade you in the event that your deduction is at best a 50-50 coin flip. So landlords, I hope this was helpful as you evaluate security deposits after tenants have vacated. Make sure that you adhere to these tips and test out your understanding of how you are applying security deposits when tenants vacate property. Make sure that you are absolutely certain that the tenant is at fault, and then make sure that you can prove these damages, both by establishing a baseline and having good evidence. Prevent much of this by conducting inspections and by routinely reminding the tenant in your lease and also in your house rules of your expectations. You do these things and you're likely going to be just fine. For even more great content on our YouTube channel, there's a video right here that YouTube seems to think that you will enjoy. But until next time, landlords, happy leasing.